Welcome. My name is Pam Metzger, and thank you for joining us here at the Deason Criminal Justice Reform Center for the first in our 2021 series of Criminal Justice Reform Scholarship Works in Progress series. Our inaugural presenter is my friend and colleague, Paul Heaton, who is the academic director and data scientist who many of you may know well from the Quattrone Center for the Fair Administration of Justice at the Carey School of Law at the University of Pennsylvania. That's a long, long, long title, Paul, but I'm gonna get it all in there. A couple of quick housekeeping announcements before we begin. Some of you may have entered this room and find yourself being listed as latent hooks. We're going to give you a minute because most of you are not latent hooks. If you want to change your username so we'll know who we're talking to, many of you, Paul and I will recognize, but for those of you who we don't, if you want to take a minute and change the username on your Zoom account, please feel free. Otherwise, we'll simply start calling you latent number 1 and latent number 2, and we'll go from there. So as we get ready to let Paul start presenting, I want to just say a quick word about this series and about our talk today. Even though it's a pandemic, that doesn't mean scholarship stops happening. In fact, and let me just check in, people can hear me, correct? I just got a chat message from someone saying they can't hear. Can I get a thumbs up from people who can hear me?
I can hear you, Pam.
Okay, so latent hooks number 3 is I think the one who can't hear, but we'll work with you on that. So quick word about it. We may be remote, but that doesn't mean that our scholarship has stopped. And so here at the Deason Criminal Justice Reform Center, we're continuing to do our work in our 3 areas of expertise, which are public defense, prosecutorial charging discretion, and STAR criminal justice, small, tribal, and rural criminal justice systems. And as part of our work, we like to be engaged with a wide range of scholars from around the nation, sometimes in subjects that are right up our alley, like the conversation we're having today, and sometimes in some more diverse areas. In fact, I see Sandy Mason on the call. Sandy will be joining us and doing one of our presentations in the spring semester. So we're very excited to see you here. So Professor Paul Heaton is going to talk today about a project that he and I are actually working on together about public defender organization and case outcomes in the case of Seattle, the King County Public Defender, and their unusual circumstances. It's research that we were both thrilled to be doing, funded by Arnold Ventures, which we're very grateful for. They've done a lot of work in this area and we're excited to be doing more with them. So Paul, I'll let you take it away.
All right, great. Thanks so much, Pam. So hopefully everyone can see the screen. Thanks so much for spending some time. I think the way I'm going to handle this presentation, if it's okay with participants, is I'm going to go along. If you have questions of clarification, we can just take those as we go along, and you'll just have to be aggressive about getting my attention because of the format. And then, you know, if you have more substantive comments and other things, please feel free to, we'll have some time at the end to kind of go through those. This is actually a pretty new, novel experience for me in a couple of respects. The first respect is this is the first time this has ever been presented to, kind of to an audience outside of the Department of Public Defense. So, you'll notice we didn't circulate a paper, right? Because there is no paper at this point. We're still working on it. And so the good news is that means we have lots of opportunity to incorporate insights and thoughts from those in this group. And in fact, I'm going to need your help in kind of thinking about and interpreting some of the results. The other way it's different, so I'm going to try something a little new here. So in the chat, I just sent you a link. And for those who want to participate in this way, if you click on the link, you don't actually have to sign in, just click on the skip sign in. It'll take you to a page that actually has all the slides. So I've had the experience at these seminars of listening and going along and thinking, oh, what about this? I have a question about this, all these ideas. And then you get to the end and in the Q&A, maybe there's time to ask like one of the 10 questions that came up. And if you're like me, right, you always have this aspiration that, oh, I'm going to write an email afterwards and kind of explain all these ideas and give the suggestions. Some of you are good citizens and do that. What happens to me is then my kids come in and then I look at my inbox and there are 100 new messages and I never get around to that. So what you can do is click on this link, you'll see the slides, and there's an annotation platform. It should work on any device. So as we go along, if you have ideas or thoughts, and feel free to just type the annotations, write it there on the slides for us. We'll take a look at those afterwards, and hopefully that'll lower the barriers to providing your good thoughts and comments. And if you're curious, you can also see some of the other things that other people are contributing. All right, so the topic for discussion today: public defender organization and case outcomes. And so the starting place that I want to start you with is something that's familiar to a lot of us, I think, who have done some research on public defense. So if we were to ask, how could we come up, if we were starting afresh an indigent defense system in some jurisdiction that didn't have one, and we wanted to make sure it was a high quality indigent defense system, like what would we do? And so, kind of the typical guidelines and kind of prominent guidance as to how do we make public defense good in some sense, of course, are the ABA principles of public defense, of indigent defense systems, 10 principles. People in the field call them the 10 commandments, right? Because they're viewed as being kind of fairly essential. Prominent place, a lot of public defender organizations, kind of benchmark their performance in reference to these principles. There's been a significant effort that many folks on the call have contributed to recently to revise and update these principles to take into account new knowledge. You can see on the slide what the 10, kind of draft new commandments are for discussion, right? And so, I would say that this kind of represents, hey, this is, kind of the state of the art in terms of our thinking. If you wanted to have high quality public defense, what would be the important things to do? So I'm hoping by the end of the presentation to complicate our view of these 10 principles a bit, right? And so we're going to present some research that to me makes me, a little bit maybe unsettled about some of these, and I'll explain why. So to get into that, let me kind of explain the context and explain the research that we're doing. So I'm going to describe some research that's set in King County, Washington. Hopefully a number of you have had a chance. You either live in King County or you've visited there. It's where Seattle is, pretty large county, about 2.2 million people. For the Northwest, fairly diverse. Includes Seattle, but large geographically. Also Kent, another large city, doesn't quite extend down to Tacoma. So the results I'm going to present today are results that are taken from King County. Now, why might King County be an interesting place to look at if you want to learn something about public defense organization, indigent defense? So, if you're like me in a place like Philadelphia, you're used to the idea that in your jurisdiction, there's a public defender. We have the Defender Association. In a lot of counties and other localities, right, there's one prominent public defender organization. For some of you in Texas, right, until recently, maybe there was no public defender organization. And so you're just establishing those. Right, but the norm, and I think what we usually think of, and there's some exceptions, right? We're familiar with New York City, where there's a number of different public defender organizations, Los Angeles with its alternate, but the norm that we think about is there's one public defender organization operating in a jurisdiction. Now, if you think about that in terms of understanding which sort of public defense practices matter, that's actually kind of tough for research, right? Because what it means is that if we wanted to do comparisons across different public defense organizations, essentially that's going to involve doing comparisons across different jurisdictions. And so if we see differences in performance or outcomes, it might be pretty tough for us to know, well, hey, is this really about how we've organized and structured indigent defense? Or is it just that there are these jurisdictional differences, different courts, different prosecutors, maybe different local norms? And is that really what's driving any differences we observe? So that's one of the persistent challenges, which I think has limited our ability to accumulate knowledge about which public defender practices work. So it turns out that King County has a very interesting history that makes it kind of a unique place. and a unique place that's very helpful for this research agenda. So what's particularly unique and interesting about King County? So historically, rather than having kind of a single public defense organization, King County actually had four separately organized, separately run public defense organizations, each with their own history. I think I saw Bob on the call, you know, the originator of one of these, right? So somewhat unusually, right, in the context of a single court system, you know, we have the same district attorney, yet we have these different public defense organizations. I'll tell you just a little bit about each of them. You can see on the slide, sorry, this is tiny. These are actually the old web pages for each of the four that existed, right? One, for example, the Associated Counsel for the Accused, it was founded in 1973. You know, by kind of the 2010s, it became the largest in terms of numbers of people of the public defense organizations. It grew rapidly at one point after it absorbed another agency. So, you know, kind of in more modern periods, some people in the system think of that as kind of like a primary defender in the sense that it takes a diversity of cases. It operates kind of throughout the county. It was the defender which, when King County started developing its drug courts, it, you know, built a specialized practice around drug courts. Again, you know, kind of storied history. So ACA, but that's just one of them, right? Another organization arose actually a few years before ACA in 1969, the Defender Association. This was a public defense organization that was created through a Model Cities grant. For many years, it was the largest of the public defense organizations in King County. Again, like the ACA, handles a variety of cases and locations, and this was an organization that was unionized. We also have the Northwest Defenders Association. This is a newer public defense agency. It was founded in 1988. At the time of its founding, there were some concerns about potential underrepresentation of minorities and women among leaders in the public defense community. And so Northwest Defenders, you know, one of the ideas is its founding was to, you know, create a new structure where it could be more inclusive. And so, you know, we have Northwest Defenders, and then finally we have the Society of Counsel to Represent Accused Persons, SCRAP, founded in 1976. This was an organization which initially people were thinking about kind of the growing number of juvenile cases, and so initially thought, hey, we're going to have some specialized juvenile practice. It branched out and began taking other types of cases, traditional criminal cases, and it had a little bit less historically of a presence in certain courts like the Seattle Municipal Court. Now, the interesting thing that happened in King County, though, is we have these four organizations, and, you know, they were managed through a contract with the county, and some employees said, you know what, we're de facto county employees, we really ought to be able to participate in the county's pension system. And so what do good lawyers do? They sue, right? And it goes to the Washington Supreme Court, and the Supreme Court agrees with the public defenders. And at that point in 2013, the county says, you know what? If the Supreme Court is going to make us treat people like employees, they might as well actually be employees. And so a plan was developed to reorganize and create a Department of Public Defense, a county agency that would essentially absorb these separate public defender organizations. So we now have this umbrella agency, and I apologize if you can't quite see the text. It might be a little small for some of you. This is the current website of the Department of Public Defense, DPD, and you'll see there are four divisions listed, four parts of the, and you know, the names will be familiar: ACA, NDD, SCRAP. So they took these previously existing organizations, put them under the umbrella of the DPD, and now they exist as divisions. Now they've been able to retain a lot, at least over the period that we've studied, a lot of their identity, right? Initially, they had separate offices. You know, they have their own leadership. They have separate hiring. Their approaches to managing cases, they were able to retain. But they ultimately developed a common case management system. And again, they're operating in kind of the same court system with the same district attorney. So potentially kind of this very unique and interesting opportunity where we see these different divisions with different practice styles and different approaches to public defense, all simultaneously operating with a common pool of clients in the same court system. So we look at that and said, that seems like kind of a cool opportunity that maybe we can measure the differences and kind of try and unwrap the black box of public defense. And does it matter if you do X versus Y? And so that's kind of where this project came from. If you're kind of curious, at the time of the merger, you can see, again, varying size of the underlying constituent divisions, but all, fairly large, fairly substantial budgets. So what I'm going to describe now is our project, which basically has two components, and I'm going to focus more on the first component today, right? So one of the things that we might ask with this unique system is, do the divisions operate, are there any measurable differences in what happens to clients depending on which division they get sent to. And so I'll describe an empirical analysis of administrative records where we try and measure performance differences. And to be upfront, right, I'm going to say performance differences, but we kind of recognize that quality defense is a multifaceted thing, and I'm going to look at the same sort of outcomes that people typically look at, like convictions and other things, but we kind of recognize that, this is like a which thing, and there's lots of things, client satisfaction, are they heard, that we're not going to be able to capture here. Now, in addition to looking at those, we're also going to try and collect some qualitative data through document review, through interviews that we've done with current, former public defenders, with judges, other people involved in the system, to try and just better understand what are these differences and to what extent might they explain some of the patterns that we see in our empirical analysis. So let me tell you a little bit about the data that we use. This was a long process to get access to the data, a few years, but ultimately with a lot of good work and help from folks in DPD, we were able to get access to administrative records from their case management system. And again, it's a joint system that includes information from all the individual divisions. The administrative records are, kind of similar in a lot of ways for people who have worked with these sort of data. So you have some information about the characteristics of defendants, like age, race, zip code. We have some limited information, not complete prior criminal histories, but at least criminal histories as they exist within DPD. We know stuff about the characteristics of the case, like where was it tried, when, what are some of the charges, and also some information about what happens in the case. Is the person convicted? What's their sentence? We're going to focus attention, and the results that I'll tell you, since these are all coming from DPD files, right, we're not including other people who might get appointed counsel, who might retain private attorneys, right? These are all people who are clients of DPD. And DPD actually has a practice which does beyond kind of criminal. There's juvenile, there's family court, kind of a range of other types of representation. The results I'll show you today are focused particularly on the misdemeanor and felony practices, so we're kind of focusing on the core criminal. At the end of the day, we have a sample of a bit more than 60,000 cases spanning from 2013 to 2017. And those are kind of the results that we'll talk about. We also, interestingly enough, were able to get access, and this is somewhat unusual for a study like this, about information from kind of the timekeeping system to let us know something about kind of personnel allocation and time allocation to particular cases. And I'll talk a little bit about how we use that in a moment. So there are the data. You probably are wondering a little bit about the case assignment system, right? So is it the case that maybe certain divisions are getting like weird clients that would make it hard for us to do the comparison? And so I'll tell you a little bit about that. So the way this system works is what I'd call kind of an assignment wheel, for those familiar with the term, with some constraints. So the way it works is each of the different divisions in a given month is given like a certain allocation of cases that they anticipate doing over the course of that month based upon their available manpower and some of the size and some of the contractual arrangements for the division. And so a new defendant comes in and they do some conflict checks, and they check to make sure they qualify for indigent defense. And ultimately it gets sent to DPD, right? And at that point, someone within DPD looks and they say, oh, okay, you know, based on the month's allocation, and, you know, the Northwest Defender Division, they could use another person, right? So we're going to slot the person over there. And so there's this kind of load balancing exercise where when new people come in, we try and allocate them across the divisions in a way that, you know, kind of makes sure that we're filling the quotas appropriately as the basic process. Now, there's some constraints on that. They tend to try when feasible and when there aren't conflict issues to slot people who have worked with a division in the past to that same division. There's some caseload limits that in some cases might require them to take defendants and shunt them to appointed counsel. Rarely, there's some locational things. I'll show you some statistics in a moment that demonstrate that the divisions have slightly different kind of geographic operations. And then there are some specialized types of cases like juvenile drug court cases that are going to be slotted to particular divisions. So it's not, you know, like they're literally flipping coins. What, when we talk to people about this process, they have said is there isn't a sense with anyone that we've talked to, and nor has there been a sense in other reports that say the county auditor has done that there's any sort of like effort to manipulate or slot, you know, oh, this is the, you know, this is the high skill division, let's slot all the hard cases over there, right? It's really based mostly on the information that's available in terms of who needs some additional cases. But that's how they're kind of allocating cases. All right, let me actually show you some summary statistics. Now, from here on in, for reasons that I think will become apparent, I'm not going to reference the divisions specifically. We're just going to call them divisions A, B, C, and D. Right? So here are the 4 divisions, and some kind of summary statistics that describe the sort of defendants that the different divisions see, some information about the characteristics as measured based on these, you know, 60,000 or so cases. You can see that, you know, demographics fairly similar across the divisions, similar composition in terms of, say, zip code poverty rates, but there are also some differences, right? So some of the divisions operate more exclusively in certain areas, and that's taken into account in some cases in the allocation scheme, you know, divisions B and D. Some of the divisions have a little bit more prominent felony versus misdemeanor practice, and so that can come up. You know, so there are some differences. And so in our analysis, we're going to want to try to the extent possible, you know, account for some of these observable differences. So kind of the main analytic approach that I'll show you some results from is something called a regression analysis. And basically what we want to do is we want to model some outcome, say whether or not someone was convicted, and try and explain that based upon a set of indicators which indicate which division they're assigned to. And then we're going to try and control for a bunch of additional stuff. Basically everything we can observe about the demographics of the person, their prior criminal history, detailed controls for the charges they face in their case, the location of the case, when it occurs. And so conceptually, what we're trying to do with these regression analyses is imagine, let's take 2 defendants, similar demographics, cases at the same time, same charges, same criminal history, but one of the defendants is assigned to Division A, another is assigned to Division B. On average, what would we expect the difference in, say, the conviction rate to be across those 2 defendants? And so that's what the regression analysis is going to deliver for us. So when we do that, and the results I'll show you are basically ones that kind of try and adjust for all of those factors. And, you know, for those of you who are familiar with this analytic approach, you know, you're going to have some benchmark or reference division. Here we'll use Division A as the reference. So I'm going to show you a series of charts which actually measure kind of average performance differences across the divisions. And the way to understand that is imagine that, if we took the pool of defendants that Division A sees and have Division B, C, and D see that same group of people, what do we think the differences and the outcomes would be, if we had that common pool of people? And the regression allows us to adjust for differences. So that's what we're doing. All right, so let me actually show you some of the patterns that we see here. All right, so the first pattern, and here, conviction rates, right? So do we see divisional differences after we control from the charges and the timing, right? So it isn't that, hey, Division C, right, it's seeing clients that have more serious charges or different types of people because we've controlled for all of that, right? All right, so how do we interpret this? So Division A on average, if we, about 63% of the people who come through and get assigned to it, the criminal defendants, ultimately end up with a conviction in their case. People who don't, either the case is dismissed or they might be diverted, right? And so the comparative charts, right, for B and D, that instead of 63%, it's 68%. And for those who are statistically inclined, these little arrows, right, are giving you 95% confidence intervals on those. So you can see that there's a statistically significantly different and higher conviction rate for divisions B and D relative to Division A. And then if you look at Division C, again, even higher conviction rate, about 72%. And again, statistically significantly different and even higher than B and D. So we've got A as the lowest, B and D kind of an intermediate, C is the biggest. Now, one other thing I want to point out about this, right, is in terms of the actual magnitude of the difference, right, it's not trivial. About a 10 percentage point difference between C and A, which relative to a base of, 62% means we're looking at, around a 15% increase in your likelihood of being convicted. So there's something, that I think seems practically important in terms of what's happening to defendants. So if we measure that as, did you pick up a conviction at all? We have that over here. If you like, if we just take the total charges, what fraction of them did you see a conviction? Kind of fairly similar patterns. So we see some differences in conviction rates. All right, what about the leniency of your actual sentence? And this is not conditional on being convicted, right? So this is just taking everyone. So, if you end up not being convicted at all, right, you're not gonna fit in these categories. So in Division A, 23% of people get a sentence which includes some sort of jail, prison, some sort of custodial sentence. If we look at B, only 18%, and again, statistically significantly lower for B. C is higher, 37%, and again, in relative terms, that's a fairly large increase, right? About 15 percentage points, so maybe you're increasing someone's likelihood of getting a custodial sentence by about 2/3, so pretty large difference. D looks kind of comparable to A. What if we look at probation as the sentence? There, again, some kind of interesting patterns. B looks similar to A. D is lower now in terms of probation. And C also kind of elevated relative to the other divisions, fairly substantially so. Let me just show you one other outcome. If you want to think about this in time in custody, average days of jail. Again, for the statistical geeks, right, we use a different model, a Poisson count model here, but same basic idea, right? So here we see on average, right, B and D getting shorter custodial sentences, C getting a lengthier sentence here. All right, so let me just take a moment now and just kind of summarize and describe what I see in those patterns, right? So we have a couple of divisions, B and D, that have higher conviction rates, but across various metrics, the actual sentences seem to be more lenient, right? D, about the same custody rate, but less chance of probation, which means on average, they're getting more people with community service or fines. B, a little bit less custody, about comparable probation. Now, which of those is better or worse? A little bit, I don't really have a great intuition. I'd be interested in your thoughts. I feel like those are just kind of different. All right. C, on the other hand, seems to be an outlier in the sense that conviction rates are higher and the sentences are longer, right? So from the perspective of the defendant, that doesn't seem to be, doesn't seem to be a trade-off. On average, that doesn't seem to be a desirable set of outcomes. So if you think of quality as being, can you get kind of the best outcomes for your clients? C looks like maybe it's operating differently from some of the other divisions. The magnitude of the differences are practically important. Now, one of the interesting things that, I take from this is we have, I think a common idea that we have in public defense research land, right? And a story that we tell is the idea of this kind of going rate, right? So that after public defenders and prosecutors get experience in the system, they kind of figure out that for a particular type of offense that, this is a likely sentence, and they use that as a basis for plea bargaining. So these results maybe might challenge that a little bit, right? It reminds me a little bit of my colleague David Abrams and Al Yoon's work on public defenders, showing less experienced ones get kind of different sentences than more experienced ones. So here, again, it's the same prosecutors, same judges in courts, but here there isn't a single price for a case, right? It seems like, in fact, depending on your division, you're getting some different outcomes. Now, one of the things that we've tried to do is cut the data in various ways to see, hey, is this really about felonies, misdemeanors? What if we look at different years? What if we look across different locations? And when we subdivide the sample in, a number of different ways, basically, we get fairly similar patterns to what I just showed you for the whole sample. So that suggests to me that maybe there's something kind of institutional about the divisions that seems to be different. So someone asked in the chat about average days of jail, pretrial or post-conviction sentences. So these are the so these are actually the final sentences, so it doesn't take into account pretrial detention. And of course, you might get time served credit for those who were in detention. We actually didn't surprisingly have great data on the amount of time in pretrial detention, so we couldn't separate that separately. That was a great clarification question, thanks. And so that's one that, and so this is kind of final sentence here. So at any rate, it seems like, given that across various types of samples, maybe there's some suggestion that there's something, about the organization or the culture or something about the divisions that seems to be fairly constant across these different types of cases that's leading to some of these different results. All right. So now we have this timekeeping data. So Bob has this good comment. Yeah, tell us a little bit about, are people using, maybe there's some, maybe people are handling cases in ways that are relevant that could affect. So the timekeeping data, imperfect, right? We do think there are some incentives for the attorneys, at least, to record this pretty well, because actually it turns out how they record time on the cases affects that allocation process. And so if you do a bad job keeping time, then maybe you get like more or fewer cases than you ought to. And so there were some efforts, but there have been some claims that, like any timekeeping process, there's some challenges. There's some challenges in terms of the, of getting people to like fill in very precisely, right? But those are the data that we have. We had a research assistant do a lot of work to try and, yeoman's work to put this all together. And so here's some summary statistics which actually describe, based on the timekeeping data, maybe some differences in how divisions are doing. So Bob alluded to, well, what about expert use? And yeah, we do see in the data, there's some variation across divisions. So division C seems more likely to use experts, or at least to record that in the timekeeping data. We also have information about how much attorney time gets billed to the case. And again, we see some interesting divisional data. Information about how many people are touching the case, right? So B seems to have a few more people touching the case than some of the other divisions. Interestingly enough, when Pam and I came into this, sorry about the phone ringing back there, came into this project, one of the ideas that we had is, we had heard anecdotally that the divisions varied in their commitment to vertical representation, and that some emphasize that a little bit more. So we thought, oh, hey, maybe this is going to be a paper about, like, does vertical representation matter? If you look in the timekeeping data, there are, again, some variations across divisions, but maybe a little bit less than we expected, right? So if you define vertical as, in the timekeeping data, is there only one attorney, or is it, is there only one attorney, sorry, who billed time to a case? We're going to call that a vertically handled case, right? And there's a bunch of nuances and things, if people have questions about, that we can discuss later. So we do see some differences. So I guess the natural question is, all right, maybe it's about this stuff, right? Is this what's, is this what's explaining? So one of the things that you can do within that regression framework I described, right, is we could run similar analyses to the ones that I did, where we try and explain outcomes using the identity of the divisions as predictors. But we could actually control for some of this stuff, right? So we could include as a control, say, was the case handled vertically by our definition? So if you did that, right, what would happen is, if what was importantly different about the divisions was how vertically they were handling their cases, then once you controlled for vertical representation, then we should expect to no longer see large differences across the divisions. That's something, in some disciplines, it's called a mediation analysis, right? But we're trying to understand, is the thing about the difference, the divisions that matters for those results that I just showed you, is it this stuff? So we did some analyses like that. So this is actually just a replication of what I showed you previously around conviction. Again, we have A with the lowest conviction rate, and after adjusting for demographics and other stuff, B and D kind of on par, and C a little bit elevated. So what happens now if we construct the comparisons, but I'm just going to control for vertical representation? So I'm going to shut that off as a reason why the divisions might differ. So we see a little bit of a change. D looks a little bit more like C, but not dramatically different. Well, what if we control for how many attorneys and non-attorneys were assigned to the case? They're kind of similar. What if we control for whether or not you use experts in the case? Kind of similar. What if we control for how many minutes, how much time the attorneys spend on the case? Kind of similar. What if we control for all that stuff simultaneously, right? We're kind of, it's something pretty similar to what we got previously. Again, the timekeeping data may be a bit imperfect, but kind of interestingly, what this seems to suggest is at least some of that observable stuff about how they're handling cases, even after we try and account for that, we're still seeing these, similar differences, B and D elevated, C elevated. And if I were to show you the other outcomes, very similar patterns, right? So controlling for this stuff doesn't seem to be sufficient to explain what's going on about the divisions. All right, so where does that leave us? Well, it's kind of a question, right? I mean, it seems like you were probably hoping, hey, Paul, you're going to tell us, okay, why is one division performing differently? I'm not sure we know the answer, but I do, want to come back to where we started, right? Principles of public defense. This is what we need for high quality public defense. Well, you'll notice something. a bunch of these things aren't different across the divisions, right? They have the same case management system, the same degree of independence, the eligibility criteria, and it's a common pool of clients. They have a similar appointment process, their role in the justice system, it's all the same. So none of that stuff is kind of different across the divisions. I've just told you, to the extent possible, we've tried to actually measure and control for continuity of representation. That doesn't seem to be. There maybe are some differences in terms of the types of attorneys that go. Can we measure that or not? Not sure. We're working on that. Maybe something about how we represent clients. But to me, kind of the interesting thing, right, is even after we, in one sense have accounted for all these things that we think are super important, it doesn't, we still see these big differences in performance, right? So where does that leave us? I don't know. This is where we're going to have a discussion and you're going to help me think about it. One question that I have is, right, maybe there should be 15 commandments or 20 commandments, right? And we just haven't figured out what the other 10 are. Is that the possibility? Maybe we need a different 10. At baseline, what this suggests to me, right, is there is something else important about practice styles, about organization, that isn't maybe being completely captured here, but that we are kind of seeing in the data. In some of my own past research, right, I think it's natural in this domain to think about, well, public defenders versus private appointed counsel, lots of discussions here, maybe, that's, overly limited, right? And we're seeing within the context of public defenders, consistent with my, work on holistic defense, as well as that of Andy and others, right? Maybe there's some important differences. So, I think a lot more to figure out here. Maybe we've left you with a little bit of a puzzle, but I think hopefully an interesting puzzle that can help us to think a little bit differently about and challenge some of these basic ideas we have about what it takes to make high quality indigent defense. A lot more work, more interviews, data collection, and I'm looking forward to your questions and comments now. So thanks.
Paul, you still have a number of comments and questions in the chat box if you want to start there. Otherwise, we can open it up to conversation. What's your preference?
Well, let's do, I bet some of these have probably gotten captured in the document. So let's go ahead and do the conversation. And if we need some clarifications on those things, I can try and raise those as part of the conversation.
Paul, can I ask you just, well, people, because I can see hands raised. I don't know if you can see them, but Bob has a question and Sandy has a question.
All right, Bob, go for it. Thanks for being here, by the way.
Well, thank you. Obviously, I'm very engaged with this issue. I have a whole series of questions. Did you measure the use of social work by division? Is there a difference between Kent and Seattle? Is there a difference in conviction rates between misdemeanors and felonies or between adult and juvenile? Did you look at diversion at all, in post-filing diversion, so that the lawyers were able to get cases diverted, and so therefore that affected their percentages? Did you look at motions practice, use of investigation? To me, all of those things could really vary. And in Kent, there's a lot more sex cases by percentage than there are in Seattle, and so that would affect issues as well. So those are all the questions I raised. I also put some comments in your slides. The origin of NDA is not exactly the way you described it. I'd be happy to talk about that more fully. So those are my questions, and I appreciate the opportunity to talk with you about this.
Yeah, thanks. And thanks in advance. Looking forward to looking at the comments on the slide. Yeah, I think those are good questions. Let me try and get through a number of them. we didn't control directly for social workers. So one of the things that's a little bit tricky in the timekeeping data is it's not always the case that for a particular individual, their role is consistently recorded. So we have some people that show up as like coded as being, you know, kind of one type of staff in one case and one type in another. And for the social work designations, we weren't 100% confident that we would like label people, right? So we kind of did a generic attorney and staff divisions. There's some separate fields that record use of experts, which is why I was able to do that. We didn't actually draw that out from the timekeeping data per se. But that's, you know, so I think that's a good question. I think that's a great possibility, right? And that's one of the reasons why in my slides, you know, one of the things I didn't check off was this, you know, kind of comprehensive representation, because maybe the social work I think of is a little bit, you know, in that domain. We didn't focus on the juvenile cases here, so not, you know, I don't have a ton to say. Kent versus Seattle, fairly similar patterns, right, to what when we break it up and kind of look specifically at places. So kind of still see those divisional differences. With respect to diversion specifically, right, you know, that's kind of captured in the conviction rate because, you know, a lot of, you know, there are a fair number of dismissals, but a lot of that is, you know, kind of coming through some diversions. I've actually done that analysis off the top of my head. Your question is making me want to go back, and at the time I don't remember seeing remarkable patterns, but now I'll go back and look because I think that's a good suggestion. So yeah, I'm hoping I covered most of those. So some a little bit unsatisfactory, like the social worker I think this is a great point. Some of them I think we've covered with the kind of geographic differences.
What about motion practice?
Oh yeah, motion practice, yeah. So we've been working on that, but it hasn't been as successful as we want. I mean, yeah, so yeah, I mean, I don't know if you want to talk a little bit about that, Pam, you're certainly welcome to, but yeah, so I think that that's to the, you know, can we develop some measures of, you know, aggressiveness or motion practice or something like that? And the administrative data that we have, I feel like it's a little bit limited because of how things are recorded. So one idea we had was to identify kind of a set of cases that we thought, you know, the motion practice could be particularly important, and actually go through and review some of the case files in order to be able to see if there are some differences. We've had some conversations, but not been able to identify what we think is a really good category of cases to do that with. One of the things that we are exploring now is the possibility of using a survey to try and understand maybe if there's some differences by, you know, kind of asking attorneys to kind of reflect on recent cases and tell us a little bit about that. But it's a great point. It's one that we've kind of thought about and we've wanted to measure better and haven't done kind of as well as I would like at this point.
Yeah, I mean, Bob, to follow up, what Paul's talking about is we started thinking about, you know, what are characteristic behaviors that we might associate, for example, with adversariness or with holistic representation. And so, you know, implicitly when you're talking, for example, about social work or diversion, right, you're talking about ways of understanding defender role. And this idea of motion practice, whether at the bond stage or in pretrial motions as a proxy, was really interesting to us. It's hard to get at the administrative stage, and my appreciation of the way motion practice was actually handled is that the way motion practice is attenuated, right, and pushed toward the end, toward right, you know, right at the time of trial, makes it really difficult to tease it out. And so we'd really be interested in your thoughts about what other potential indicia there are about behaviors, whether they're about holistic behaviors or adversary behaviors or any of the things that fall into those two categories that Paul left unmarked on those 10 principles.
Well, let me just offer two things. I don't want to monopolize this despite my interest in doing so. One is that motions can be raised with the prosecutor and not actually litigated.
I know.
And that can, I mean, that's something I'm observing in some of my work now. And so that's something, if you do surveys, you may want to look at. I'm really interested in the expert usage and what kinds of cases the experts were used in, because my guess is there may be some differences there, both within felonies and between felonies and misdemeanors, between Kent and Seattle. I think there could be some real differences among the divisions there. And then in terms of sentencing advocacy, whether there's written sentencing memoranda or not, and whether experts are used at sentencing and community people called at sentencing. So I think there's things you could get at with your survey perhaps that are not recorded in the data. Thanks a lot for letting me ask all these questions.
And thanks for those comments. And let me also actually respond to one comment I'm seeing from you in the chat. Right? You know, to be clear, right? I'm not trying to denigrate the 10 commandments, right? I mean, hey, I live in a county, right, where we just, you know, crazily fired our public defender, right? You know, so like I appreciate the importance of independence, right? And I definitely think that those are important principles. But what I am saying is, you know, maybe, again, maybe there need to be more, right? And you know, I think it's fair to say that the level of empirical evidence we have regarding some of these, just because of the difficulties of doing comparisons, is somewhat limited. And, you know, one of the things that I find fascinating about King County is it suggests, you know, that there's other stuff out there still to be discovered that could be pretty important.
But the ones that you've left unstricken, experience and supervision and training, those are critical, and they're built on all the other ones being in place. All the places in the country that don't have caseload control, that don't have adequate funding, that don't have decent salaries, that don't have support staff, that don't have independence, that aren't a presence in the political system, those places really need the ABA 10 principles. So in a sense, you're looking at a fairly strong system that has differences within it. But if you compared it to a place that didn't have those 7 that you've stricken, it would be very different.
Fair point, yeah. Sandy, you had a question.
Thanks. Nice to see everyone here. This is fascinating, Paul and Pam. First, a set of clarification questions. With respect to possible factors external to public defender divisions that might account for some of the differences. So first, is there any possibility you're seeing some judge effects? Pam wrote me no, there's none, but I'd love to hear more about that. How do you know, does each division appear with equal frequency in front of the same judges in the same courtrooms, et cetera? And then secondly, related, same question with respect to prosecutors. Do they all work equally with the same prosecutors? And third, case types. I think this is something Bob mentioned, but I just was unclear. Did you control for differences in their caseload composition with respect to case types, like, you know, violent offenses, violent felonies, nonviolent, sex offenses, drug offenses, et cetera, DUIs?
Yeah, let me answer those, and then if you have some kind of additional thoughts or comments, I'd love to hear. You know, so we didn't literally so the data don't literally record the identity of the prosecutor or the judge. So it's not as though like we have a bunch of judge or prosecutor fixed effects. But you know, there are different prosecutors and different judges seeing the different divisions, and you know, kind of in our interviews and stuff, people have not suggested that is, you know, that would be, they don't view that as like a plausible reason to expect the differences, to see differences across the divisions.
Because they all see all of the judges?
Yes.
And now with respect to the types of cases, yeah, there we do have pretty detailed controls. And so, you know, we have like, you know, based upon the combination of charges, right, we have like hundreds of different individual controls. So we're actually trying to match people pretty finely on, you know, kind of the charges when we do those comparisons.
Awesome. Can I ask just one more
question?
Yeah, I'm curious whether your data would enable you to look at the case outcomes by individual lawyer. And if that's something you'd consider, that might be raise some ethical questions, but I see, Pam, 10% difference in conviction rate is a lot, but I can imagine just a handful of lawyers having a substantial effect.
Yeah, well, okay, yeah, I mean, so it's interesting, right? So in theory, we could do that. We haven't looked at that at all. Of course, if you remember my vertical slide, and there's no reason you should, but I'll just kind of refresh, a non-trivial number of cases have multiple attorneys billing time. And so then the question becomes, how do we attribute those? Or, like, which lawyer is it? Is it the person who spent the most time? And again, this is very much, thinking back to David Abram's work, right? He finds some pretty important differences. Not something that we've kind of dug into that much. Like one variant of what you're saying, right, is like, is the within,
right,
is the cross division variation greater than the within division across lawyer variation?
Exactly.
And if it was or wasn't, then that might tell you something interesting about the division. I think we could do that. It's not, thus far I've kind of stayed away from kind of this specific lawyer specific analyses, but that, in principle, I think would be possible.
And Paul, if I remember correctly, one of the things we talked about, of course, is that this difference persists across time in systems where people move out of misdemeanors, for example, into felonies. So, whatever's happening there is happening across time over a period of nearly 4 years. I think Ingrid Early has a question.
Yeah, Ingrid, this is a pleasant, yeah. Thanks
Hi,
for
nice
joining.
To see you.
So
Yeah, of course. This is such a great project. I just wanted to chime in with a question. I've been doing some research in the California public defender system and the adoption of immigration experts in the different public defender offices. And it seems like in what you presented in terms of outcomes, a lot of it is in terms of sentence length. But with the Padilla decision since 2010, outcomes that are, required for public defenders to pay attention to also include likelihood of deportation. So I'm wondering, if there's a difference across the offices in terms of, how they handle non-citizen cases. Have they hired internal immigration experts to consult on every case? Do we have a sense of the percentage of non-citizens in the caseload? And could that be causing some of the measured differences in terms of conviction or the types of outcomes in sentencing?
Yeah, so great question. So I can tell you what the data tell us, which is the data with respect to these issues, at least the administrative records, are kind of bad, right? So, so in theory, the attorneys are supposed to, kind of like fill in some information about, kind of, citizenship, immigration, other matters. And so, it's kind of natural to want to look at that because I think it's kind of a great question. When we actually dealt in, it seemed that the quality of the recording for those seemed to be worse than many of the other fields, unfortunately. What I can say is, at least with respect to the citizenship that is recorded in the case management system, which I'm not completely comfortable saying is like actual, controlling for that doesn't change the basic story I told you there, kind of the indicator for citizen, non-citizen. But, I'm not sure if I think that doesn't really answer your question, right? I mean, what we would really want is, better data that we have confidence is kind of correctly capturing some of this stuff. And with the data, at least I've looked at, I wouldn't feel confident saying the data are there. But yeah, it's a wonderful issue to think about.
Hey, Paul, one question we've gotten a couple times is trial rate. And I think people are maybe driving at this question about how much of what's going on is, bargaining in the shadow of trial. Can you talk a little bit about trial rates?
Yeah, right. So the overall trial rate is recorded in our data is relatively low. It's not actually as low. I found this will be news to you, Pam. So I found this unfortunate coding error. So there are actually more trials in the data than I realized. So there are about 800 or so trials, I want to say. So maybe even a little bit more than that. So I feel like the trial rate, the last time I looked at it, was about, overall across all the divisions was, I want to say, about 3%. So I guess there should be more than 800 trials. Not super high. I don't think outlandish for, I think King County is like other places. There are some divisional differences in the way at which cases go to trial. Although again, I think you want to be, so I think that that's interesting. That's not something I've even showed Pam yet. It's just some very recent analyses. You do see some divisional differences, so that might be interesting. I think it's tempting, right, to say, okay, well, hey, are people getting different outcomes at trial? I'm going to suggest as an empirical matter, we might want to resist the temptation to look at trials specifically, right? Because we know that who goes to trial is subject to some sort of an internal selection process, and lawyers are strategizing. And so I don't think we can actually infer much about, kind of differences in quality or performance based upon trial outcomes themselves, because I think there's some different strategic decisions that go into play. One of the reasons I presented all the results I showed you kind of not conditional on, hey, were people convicted and other things is, right, if you think that part of the strategy may have to do with, thinking about how to get a more lenient sentence, then, if we just focus on, say, only people who are convicted or only people who go to trial, then maybe now we really are looking at different pools of clients in important ways. But yeah, that the trial thing is something that you see some differences across the divisions. So in a later, better version of this presentation, I'll show some results on that.
And Paul, there was also a question about conflict counsel outside the 4 divisions. And I'll just note that we do have some data on that in terms of how often the caseload limits within the division, in other words, in the rotation, if all the divisions are maxed out and they had to go outside to assigned counsel. We know this was an issue in 13, 14, somewhat in 15, where there were conversations about the budget and how to manage the Department of Public Defense budget. We can certainly take a look at the volume of cases that were flowing to assigned counsel outside the divisions, but those would have been as a result of overflow, typically because of caseload, not because of 5 defendant conflicts, for example.
Yeah, right. So yeah, just to be clear, the norm is, to try and stay within DPD, and move across divisions if necessary. But then, in the very uncommon case where there's, 4 division conflict, you go out, but Pam is absolutely right. And just to be clear, right, appointed attorneys, not going to be in the data set. People who got DPD and then later retained counsel, doesn't happen a ton. If I recall correctly, not measurable differences across the divisions in the way at which that happens. But those people are going to be out. So it really is people, who are represented by the Department of Public Defense.
So one other question that came up, Paul, unless somebody else has their hand up, and I don't see anybody else with their hand up. One of the questions that came up was from Victoria Smigaki, who works here at the Deason Center, but she wanted to talk about office composition, attorney staff demographics, experience, stability, and those kinds of things. And so I wanted to mention that we are doing some of that work, but I'd like to open that topic up if folks have conversations they'd like to have about it or thoughts about it, because that's kind of the next place where we're going with this study. So I didn't want people to think we were ignoring that question.
Yeah, I mean, one answer might be that, hey, they do have separate recruitment processes, different philosophies. So is it, hey, you're just getting kind of different types of people in some way that has implications for outcomes? I guess that's a possibility. One way you could empirically look at that is collect biographical information about the attorneys and see if there's at least observable stuff. So, we're exploring exploring some of that. I would be interested if there are folks here who, and I think Bob has started us off with some interesting hypotheses of kind of other things that could be going on. But if there are others who, have, oh, maybe it's this, maybe it's that, right? I mean, I hope, again, since I'm not going to provide you an answer, I'd love for you to give me your ideas for what you think the answer is here.
Paul, I just want to ask about the recruiting and so forth, because my understanding now is that the DPD is making the decision about where new lawyers go, and it's not exclusively done by division. We certainly had different recruiting approaches when I was there before DPD took over, and to some extent, to the extent we did, that would affect the senior people that are still there. I did a lot more national recruiting than the other offices did, had a bigger emphasis on diversity of all kinds. And so to the extent that experienced people from before 2007 are still there, that would be affected because of the different recruiting policies. My understanding is that today, and I don't know during your 4 years how much of this had changed, the county is controlling who goes where. Like my students, for instance, they can express a preference, but they don't necessarily get to go there. So and the other thing is that the intern programs were very different in the 4 divisions before the county took over. That stayed a little bit like that for a while, and then the county basically scuttled that, threw it into the garbage, and it took a while to come back. So the impact of recruiting and hiring did make a difference prior to the county taking complete control of that. There was also a period, and I know because Flores Mickelson was able to change this, where the county was not willing to hire people in advance, which is something that I was doing all the time. And so that affected the quality of hiring until she was able to change that and get so-called temporary attorney slots. So you might want to take a look in your data as to when that happened. I don't recall the date of when Flores was able to get that done. So there certainly was a difference in recruiting and retention, but that I think is minimized today.
Yeah, I mean, I think that's consistent with my understanding. I guess the way I think about this notionally is I think that's a relatively recent innovation. And so if you think about the 13 to 17 period that we're looking at, like I think of that as, most of the lawyers who are in the divisions are a product of the kind of pre-existing divisional hiring processes. So that's kind of, but you're right that there's been, I think training is another area, right, where kind of at the very start, right, each of the divisions had kind of their own training paths, and over time they've tried to like consolidate that and have a more uniform training regime. And so I think some of those differences have, attenuated over time. So someone had a good question in the chat about time at which attorneys are appointed. My understanding is that, again, basically they get sent out, parceled out to the divisions in a consistent way. But then, of course, it's up to the attorney to, kind of make some judgments as to at what point in the process they're going to engage. So, yeah, so from what I've heard talking with people about the timekeeping data, so I had this like number of attorney-client meetings idea in the timekeeping data. And so it turns out like what we heard anecdotally is people, and having done timekeeping myself, right? Like I guess I kind of understand this. The claim is that people were pretty careful about making sure the aggregate like amounts of time for a particular client and case were recorded correctly, but often, right, you're doing timekeeping and it's like the end of the week and let's go back and like think back and try and record things. So some of the things that we heard, it made us think like if we added up how much time was spent by attorneys, that would be okay. But the actual like, was it 3 30-minute meetings or one 90-minute meeting? Like we got a sense that some people might do 3 30-minute meetings, and then, you know, at the end of the month or whenever they're kind of updating their files, they're just going to record 90 minutes to get the right amount of time. So I'm not fully confident. And we did look at that a little bit and try and make some measures out of it. But in the end of the day, I wasn't like 100% convinced that I was measuring that. But it's a great, great idea. Matthew, I see raising your hand.
Hi, Matthew, myself from Rand. I have a couple of thoughts, and some of which you may have looked at or are looking at, but curious if you looked at average caseload for the attorneys and also pretrial detention for the defendants and whether those were factors. And then couple of less obvious statistical ones, but it'd be interesting if you could get at either philosophy or leadership of the various departments or training of the departments. And someone else had also mentioned in the comments, a great way I think to try and figure out what a difference might be would be to qualitatively interview the defendants themselves and try and get a sample of defendants and their sense of their cases, how they were handled. And that might reveal a lot more from a person from people who've actually used the services.
Yeah. Okay. I mean, I think that those are some really nice suggestions. We have been trying with the interviews to get it to some of this, you know, culture, that, because yeah, I think that could definitely be, a potentially important thing. Caseloads, I haven't looked too much, although again, keep in mind that Washington, one of the kind of well-functioning aspects of this is they, enforce the caps and they have some caseload restrictions. So this isn't the sort of situation in like a New Orleans or another place where, you're potentially just having someone with this, hey, the caseloads are still high, right? But it's like it's controlled in a much better situation than normal public defense. Pretrial detention, right? I mean, I'm staring at Sandy's image, right? Obviously, we've written on that. That's something we think about a lot. Not recorded as well as I would like in the case management system. We actually went through this lengthy and complicated effort to try and get administrative records from somewhere else so that we could kind of get the pretrial detention that in the end didn't pan out for us. So to what extent is this like better handling of the, kind of those initial stages versus later? I wish I knew. I don't know the answer. I have another paper coming out where we ran an experiment in Philadelphia and they made a slight tweak to how they handled those earliest hearings, and it had a huge impact and improved racial disparity. So that makes me particularly interested in this question. Unfortunately, right now, I don't think the data here kind of tell us the answer. But yeah, I agree with your instincts there.
Yeah, I had a feeling there was a data limitation on that one, and that would be the answer. But thank you.
Yeah.
I guess, Paul, we should also point out that a lot of these questions about caseloads were built into the assignment system. So when the merger happens, when these become internal divisions, there's a formula for case allocations for what each office could take based on its size and its staffing. And that's monitored centrally. So nobody gets overloaded because the central staff that's assigning out from DPD where these cases are going can see when each office is at capacity. So in theory, at least, the formula that's used to allocate, really one would more call it workload in the sense that divisions are of different sizes and have different contractual obligations, but that's being monitored in a way that's supposed to keep it at equivalent levels.
There's also even an effort, if a case ends up being more complicated than expected, that you can like calculate some special credits and kind of offset. So and again, like practically getting this all to work right, kind of challenging, but I think actually a pretty thoughtful effort to really, think certainly a lot better than a lot of other jurisdictions that I've seen, right, with respect to that. So how's our time looking, Pam?
We're right at 3:15, so we're right at 75 minutes, which is a nice catch, Paul. I can always count on you to do the numbers. And so I think it's probably time for us to call it, although folks are welcome to keep adding comments on the slide and on the slides. And I know we'd love to hear from you. This has been such a fascinating conversation, and for at least for me to listen to, I've got pages of notes now, also a long list of questions that I have to go back and talk to Bob about. But I want to thank everybody for joining us. Paul, anything you'd like to add before we wrap up?
Again, just my thanks and appreciation for being here, and you know, for your comments both here, and I'm looking forward to seeing slide comments. And yeah, you've been a great audience. Thanks.
Yeah, thank you all for joining us. Just a reminder that this is the first in our series. In October, we actually have 2 events. Professor Howard Henderson will be talking about prosecutor caseloads and sentencing outcomes, another topic that may be near and dear to the hearts of many of those who are on this on the Zoom call. And later in October, Professor Jenya Turner from SMU will be talking about video courts. So lots more to come from us. We will look forward to hearing from you. Thank you all so much for joining us. Paul, thank you again for presenting for us today. And please, folks, keep the comments coming, and we'll be looking forward to seeing your input on slides or by email. Thank you all so much.